Welcome back, everyone. Time for us to go behind the headlines. And in today's story, I saw an update on the Mendocino County zip tie program. And unfortunately, the county has surrendered medical marijuana grow records to the feds. Officials in Mendocino County have complied with a federal subpoena to hand over records related to its discontinued medical marijuana registration system. Previous agreements with the feds allowed the county to redact personal information from the request, but the new subpoena has officials turning over, quote, a limited number of unredacted county records, end quote, reports the Sonoma Press-Democrat. When Mendocino County began its zip tie registration program, it was hailed as an innovative way to register medical marijuana growers. Sheriff Tom Allman was seeking a way to protect the rights of legitimate patients under California's Compassionate Use Act who wish to grow up to 25 plants for their medical use. The problem is that the county is part of the legendary Emerald Triangle, where non-medical growers produce cannabis crops for export to the national recreational market. The zip tie program began in March of 2010. PBS's Frontline reported on the program that allowed individual growers to purchase up to 25 labeled zip ties from the county for $25 apiece. Collectives could get up to 99 zip ties for $50 apiece, provided they supplied a $1,500 special permit and submitted to $500 monthly inspections. Those ties would be affixed to the plants, so when sheriffs were called to a marijuana grow, they could easily identify the legal medical marijuana grows. Patients and collectives were protected. The county made some money, about $800,000, and the sheriffs could focus on illegal marijuana grows. Well, that all ended in February 2012. Federal prosecutors warned Mendocino County it was in violation of federal drug laws. Of course, every county and every state that allows for medical marijuana is in violation of those laws. But to the feds, Mendocino was not just tolerating medical grows, but openly facilitating them. Rather than risk the expense of a court battle, the county ended the zip tie program that by all accounts was remarkably popular and successful. Now, Mendocino County has complied with a federal subpoena to relinquish redacted records from that nearly 2 years, relinquish unredacted records, from that nearly 2 years of permitting medical grows. Last October, a grand jury requested all the records, including the identities of every grower who participated. County Counsel Thomas Parker resisted that subpoena. He was concerned about the privacy of the more than 90 growers who registered for the zip ties. In April, the feds agreed to allow the county to redact the personal information from every grow record, including the names of the growers and the addresses and the parcel numbers of the grow. But the latest subpoena from September 25th requests unredacted records from a more limited set of those grows. And Parker wrote in his statement, quote, the Board of Supervisors directed that the records be provided to the federal grand jury as requested by the subpoenas, end quote. Which records got released? Well, federal law prohibits the county from mentioning which records were turned over, and they cannot even mention whether or not they contain any personal information. This is terrible news from anyone who's been trying to come up with a reasonable way of regulating medical marijuana in their state. When the Mendocino zip tie program first started, the only blowback they got on this was from paranoid growers who said, I don't want to register for those zip ties because I know it's going to get used against me. I don't want to be on some list somewhere. And, officials had to say, no, we'll protect your privacy. We'll make sure that your privacy is protected. Well, it turns out those growers weren't so paranoid, were they? Turns out that when push came to shove, Mendocino County is handing over the privacy information on those particular growers. And that just gives more fuel to the next set of people that don't want to comply with any sort of registration or licensing structure with respect to a medical or recreational program, so long as the federal government maintains a prohibition on marijuana that is at odds with the states. We've seen that memo, that the August 29th memo that said that as long as we follow the 8 priorities, the recreational states, Washington and Colorado, won't get busted. But we also saw the Ogden memo that said if the medical marijuana states followed their rules, they wouldn't get busted. And Obama went and led more raids against medical marijuana than any presidential administration. So you got to forgive the marijuana community if it's getting tougher and tougher to believe any of the promises about not getting busted when they keep getting broken. This is why the federal prohibition has to end. It won't work at the state level. Now, that's not to say you don't legalize at the state level, but that's just a step, people. That's just forcing the government's hand to realize that we've got to end this prohibition on a federal level before anyone can use marijuana and still feel free about it, 100% free. We're going to take a break. We'll be right back with Bago Schwago and our Daily Toker Tuesday.
If he said he swam to China